right. Welcome to BigTent USA, where we put democracy above partisanship through education, civic engagement, and activism. In 2024, we'll be focusing like a laser beam on three issues: democracy, women's reproductive rights, and our children and grandchildren's future. It is such a privilege for me to welcome Judge J. Michael Luttig and the Brennan Center's president and CEO, Michael Waldman, to BigTent. Judge Luttig served on the U.S. Court of Appeals of the Fourth Circuit for 15 years, from 1991 to 2006. He was appointed to the federal bench by President George H.W. Bush and served as Assistant Attorney General at the United States Department of Justice and Counselor to the Attorney General of the United States. Among his many other credentials, Judge Luttig served in the Reagan White House and was law clerk to then Judge Antonin Scalia of the U.S. Court of Appeals for the District of Columbia Circuit. And famously, in January of 2021, Judge Luttig became a Twitter user. More on that later on. Michael Waldman is the president and CEO of the Brennan Center for Justice of the New York University School of Law. He was director of speechwriting for President Bill Clinton and is the author of the Second Amendment, a biography, and the Supermajority, How the Supreme Court Divided America. Judge Luttig, Michael, welcome to BigTent. Thank you so much, and I will let you take the conversation from here.
Thank you so much, Kitty, and welcome to everybody who is part of the BigTent community. It is one of the signs of hope, I think, in our country, how many people are rallying to the cause of democracy. It really is a democracy movement that is broad and deep and diverse and across party and ideological lines. Active citizens like all of you are really central to that, and we're really delighted to be part of this conversation. I think I at least can't promise that we'll be as lively as James Carville and Sarah Longwell, but we will do our very best. It's such an extraordinary privilege for me to be in this conversation with Judge Luttig. I know I speak for so many people across this country in saying thank you to him for his voice, his courage, and the significance that it reflected when he spoke out at the January 6th committee hearings and in the course of real time when Donald Trump was trying to block the peaceful transfer of power. And he's been a great public voice for the rule of law, as we're going to hear about. As a lot of you all know, there's a lot happening in the courts and at the Supreme Court this year around elections, around democracy, and really for the first time around Donald Trump's efforts, I would argue, to subvert our democracy. The Supreme Court has been pretty good in the past about staying out of these issues. It certainly stayed out of a number of these cases in 2020, but it does seem as if it has no choice this time but to get involved. And on February 8th, the court will hear a challenge to the ruling by the Colorado Supreme Court, which probably everybody's familiar with, which said that the 14th Amendment, in a provision that for many years had been little remembered, said that if you engaged in an insurrection and that you had taken an oath as an officer of the United States, you could not serve in public office. That sounds like someone we know. This is a big ruling, and they're going to be hearing arguments on February 8th, and they're hearing from the friend of the court briefs, the amicus briefs, which serve as such an important Greek chorus in these cases, bringing in historical and legal perspective, one of which was just filed by Judge Luttig. So, Judge Luttig, I offered the other day to hold your coat on this. Your expertise on this is really quite deep. Tell us why you filed this brief and what it said and what you think the Constitution says.
Thank you, Michael, and thank you, Kitty and BigTent. It's really my pleasure to be on your broadcast today. Michael, a number of my colleagues, former Republican officials in 6 prior Republican administrations, did, as you said, filed an amicus brief in the Supreme Court yesterday afternoon on the disqualification question of the former president that's now pending before the Supreme Court of the United States. Some of us that filed that brief have long believed that that the single best argument that the former president is disqualified under Section 3 of the 14th Amendment is that he engaged in an insurrection or rebellion against the Constitution of the United States when on January 6, 2021, he attempted to remain in power beyond his constitutional term of 4 years and prevented on that day the peaceful transfer of power for the first time in American history. There is a lot packed into that one statement, all of which we explain in the brief that we filed last night. But to begin this conversation, I would point out to your listeners and viewers that the 14th Amendment disqualifies a person who engages in an insurrection or rebellion against the Constitution. That is, by its terms, Section 3 does not disqualify one who engages in an insurrection or rebellion against the United States or the authority of the United States. It was many, many months ago that the legendary Harvard professor Lawrence Tribe and I wrote an article in The Atlantic explaining that, and also that the former president is disqualified under Section 3 from holding the office of the presidency in the future.
It's such an interesting history lesson, and for all of us, one of the briefs that was filed that is worth reading, even just as a matter of narrative history, was filed by Akhil Amar and his brother Vikram Amar, both law professors, pointing out that, like so many parts of the Constitution, there was some sort of specific stuff that this provision of this amendment was responding to. And it was not only the insurrection that we know of from the firing on Fort Sumter and the Civil War, but also the conduct of high officials a few months before, including President Buchanan's Secretary of War, who, having sworn an oath to uphold the Constitution, basically allowed the weapons of the U.S. Army to be distributed to the Confederates and the property in all the southern states. In other words, that the insurrection didn't necessarily have to involve bursting in through the glass doors or firing a gun if you were somebody who had an oath. And it was pretty interesting. What do you say to people, and I will confess this has often been how I have felt about this, who that Donald Trump is guilty of having engaged in an insurrection against the Constitution, and if there's an outcome here where the Supreme Court says, oh well, he didn't, that would just be a terrible outcome, though I don't expect that. He clearly, there was an insurrection, clearly he engaged in it. Clearly, he was an officer of the United States, even though you could read that provision and wonder why the president is not specifically mentioned. But there certainly was plenty of contemporary commentary by the sponsors of the 14th Amendment indicating they meant people like the president. But that the decision about this whole matter, which is such in a sense, a new thing, has not been used for so long, that it ultimately is troubling if it's made by election officials, as in Maine, or a court in a state, as opposed to what happened with the Civil War, where there was a congressional declaration of insurrection. How do you, this is the question of, is it self-executing? How do you respond to that? Because that has seemed to me to be the biggest challenge. And Lawrence Tribe, I believe, at least at some points, has raised this as well.
Michael, those are all good questions. Let me begin to answer them, though, first by returning to your earlier observation about Akil and Vic Amar. Professors Amar are two of the finest constitutional minds in the country today. And yes, as you pointed out, they have explained to the Supreme Court not only that what the former president did on January 6th constituted an insurrection or rebellion against the Constitution of the United States, as that term was understood at the time of the framing and ratification of the 14th Amendment. But as importantly, some of the greatest historians in the nation today have filed briefs making the historical point that what the former president did in and around January 6th was the equivalent of what was regarded as insurrections or rebellions against the Constitution at the time of the framing of the 14th Amendment. So, for instance, in our brief, we're not historians and we don't pretend to be, but we did cite one example that the historians and professors have cited in their briefs, and that is the South Carolina's secession from the Union. In the wake of the Civil War, that was what we explained in our brief was that that was an effort to deny President Lincoln his powers under the Constitution to govern the only South Carolina. Okay. Whereas, in contrast, the former president's efforts on January 6th were aimed at denying the then newly elected President Joe Biden his power to govern the entire nation. The word we chose to contrast those two was that the former president's efforts were broader in their impact on the Constitution than were the efforts of South Carolina to secede from the Union. But then turning to your larger questions, first, what we all need to understand is that the disqualification that's provided for under Section 3 is not anti-democratic. It's precisely the opposite. It is one of, if not the single most pro-democracy provisions in our Constitution. What the Constitution tells us, rather, is that it is the conduct that gives rise to disqualification, an insurrection or rebellion against the United States Constitution, that is anti-democratic. That's just not even a question. There are many, as you know, and your listeners know, there are many provisions in a Constitution that one could deem to be anti-democratic. It is the Constitution that prevents all of that anti-democratic behavior, such as, for example, the electoral college. People have long thought of that, the electoral college, as anti-democratic, and under the one definition of democracy, that it is. So in the 14th Amendment, it's the American people, through their Constitution, who have withdrawn, if you will, the decision to return the former president to the White House, if he indeed engaged in insurrection against the Constitution of the United States. This is not, as the political people in our country have said, this is not Joe Biden. It's not the Democratic Party. It's really us, the American people, through our Constitution, who have withdrawn this question from public decision.
It's an interesting point that I think a lot of folks who are not marinated in these legal questions might not catch, that the most prominent argument for this before this case was actually made by some very conservative scholars, William Bodie, and a lot of the people who are most vocal in support of this disqualification are in fact folks like yourself from the conservative legal movement. And in a sense, the strongest argument is what we would call an originalist or a textualist argument. And the argument, in a sense, on the other side is a sort of, well, it's just too much. It would be too intrusive an act by the court to do this, and in a sense, the kind of thing that would have been derided as living constitutionalism or something like that, or at least an aspect of judicial restraint that Justice Thomas, for example, when faced with a choice between what he understands the original intent of something to be and current practice, he's always felt it proper to rely on what he sees as the original public meaning. Let's play prognosticator for a little bit, because I do think that it would be a really big deal for the Supreme Court to bar to recognize this provision of the Constitution as being appropriately used by the Colorado court. And I want to just see what you think of the kind of alternate scenarios of Colorado being upheld or Trump winning. And then I want to talk, before we have time for questions, about the insurrection, the other big case in front of the Supreme Court, or not yet in front of the Supreme Court, but in the courts as the web of accountability closes in on Donald Trump, which is the Jack Smith prosecution for the federal criminal trial, which is another federal case. How would it work? What would happen if the Supreme Court actually did say Colorado is correct, and maybe not just this is okay for Colorado, but he is in fact disqualified?
Well, Michael, the Constitution is neither conservative nor liberal. It's the Constitution of the United States, and as you said, it was really Professors Bode and Paulson who began this conversation that has now led to a decision by the Supreme Court of the United States. They are, as you said, regarded as conservative jurisprudence or interpreters of the Constitution, and as you said, it's their analysis that was grounded in the philosophy of interpretation known as originalism. So that is the kind of analysis that ought to appeal most to this Supreme Court, a majority of whom have proclaimed themselves originalist in their interpretation of the Constitution. Would it be a big deal were the Supreme Court to disqualify the former president under the 14th Amendment? Yes, but no, in this sense that it would be a big deal if the Supreme Court were to qualify the president contrary to the Constitution's command, in my view, that he be disqualified because of his insurrection or rebellion against the Constitution. Well, one other question, your embedded question of yours that I want to address before we move on, and that is that what's been known as the self-executing feature of Section 3 of the 14th Amendment. It is self-executing, which means nothing but that the fact that Congress does not have to act in any way whatsoever in order for the former president to be disqualified under Section 3. And what we've explained, I think, for the first time in any of the briefs to the Supreme Court, is that the question of the disqualification of any person, including the former president of the United States, is, per the Constitution, a judicial determination. That is, the Constitution vests the judiciary, federal and state in this instance, with the power to determine the qualification of the former president to hold the presidency again in 2024. That's probably sounds like a very technical point to be made, but it is anything but technical. That is the constitutional fact, among others, by the way, that confirm that Section 3 is self-executing.
Let's turn to the other big case, and I will say, and we can talk about this more in the discussion with BigTent participants. One concern that I think I have is that if, in fact, the Supreme Court does not disqualify, if the Supreme Court rules, for Trump, and I think as a political matter, there's certainly a high chance of that. He had been 0-63 in cases in 2020, trying to uphold his false claims. He will be loud in proclaiming himself vindicated. I think whatever the Supreme Court does, it's really important that they not say, "Oh, well, he didn't engage in an insurrection, so that's why," or he's not an officer. But I think that as we think about this, we need to map out a response should the ruling come out differently from the way Judge Luttig is urging, because it's all part of a kind of a symphonic cacophony of cases that Trump is trying to use for his own benefit, but also that is gripping the public's attention, and I do think will have an impact on his standing eventually. I want to ask about the other big case. We've talked about this before. As viewers know, there is a federal prosecution by the special counsel Jack Smith due to go on trial starting March 4th. That was the original start date of the trial. A very tightly drawn, powerful indictment. Former President Trump has claimed and has gone to court to say that he is immune from this prosecution because the events took place while he was president. It's basically an easy case. It is a legally easy case it has been assumed for at least a half century or more that former presidents could be prosecuted, even at the same time that current presidents probably could not be. When Gerald Ford pardoned Richard Nixon, his pardon said, well, you know, he's about to be indicted and go on trial, and this would be terrible for the country, so therefore I'm going to issue this pardon. And in accepting the pardon, Nixon didn't have any problem with that argument. The president for whom I worked, Bill Clinton, was investigated after he left office by federal prosecutors for pardons he issued as president. He was cleared, but anyway, people didn't say, oh, well, he's immune and it's not, you know, it's not something he could be investigated for. As Mitch McConnell said, when explaining why he voted against conviction in the second impeachment of Donald Trump, said, well, we all know that there's a criminal process that can take place and that we, in effect, expect to take place. This is a legally easy question, but it is a question of first impression in some ways as well, because no former president has ever been indicted or even seriously investigated in this way. And so the courts are weighing in on this. There was an argument made at the DC Circuit Court of Appeals. It was a striking argument. I encourage people to listen to the tape if you have a chance. Former president's lawyer was asked, well, could he order SEAL Team 6 to assassinate his political opponents? And the answer was, and without investigation. And the answer was, unless he'd been convicted by the Senate in an impeachment, first impeached and then convicted, maybe by the very people who would be fearing assassination, then he could not be. It was kind of one of those defining kind of crazy moments in a courtroom. I'm sure we'll hear about it in the ruling. The question here is timing. The later this all goes, the more that case is going to be thrust into the center of the presidential race. And so I have a question for you, Judge. Does it worry you that the DC Circuit Court of Appeals is taking what seems to be taking its time? I think you're less worried than I am, but you know more. And what do we expect to happen in the Supreme Court on that case?
Michael, I'm not worried, and I'm certainly not overly worried at this point. The judicial process and the wheels of justice turn very slowly, and that's because there's so much at stake. And when the judiciary speaks, it gets it right because it understands that that is the law of the land. No president is immune from prosecution for acts conducted during his presidency, provided that he's prosecuted after the time that he was president of the United States. And no court in the land will ever hold that that the former president is immune from prosecution for his conduct in and around January 6th. My colleagues and I actually filed a brief on the immunity question, both in the district court and then subsequently in the United States Court of Appeals for the District of Columbia Circuit, making the equivalent argument there that we've now made in the Supreme Court with respect to the Section 3 of the 14th Amendment, namely that a former president is never immune from prosecution, but the one instance in which he will never be immune is for his violation of the executive vesting clause and the 12th and 20th Amendment of the Constitution of the United States, which is what he violated on January 6th. So I'm not worried in the slightest. In fact, I believe that we can expect a decision from the DC Circuit any day. And then, of course, I have no better idea than anyone else, but provided the DC Circuit holds that the president is not immune, I would expect the Supreme Court of the United States to deny certiorari on that question, so that the trial may proceed within a month or so of its March 4th scheduled date, if not less than that.
That would be striking if they resisted the temptation to make a grand pronouncement on this in the manner you describe. I do think it's really important that when the DC Circuit opinion comes out, assuming it comes out the way I think we all assume it will, that all of us who care about democracy not simply pocket the win. This will be one of the most significant rulings on presidential accountability in American history. And I have a feeling it will be well argued. And it's important that the media and those of us who care about this stuff not simply say, well, now on to the Supreme Court. It's extraordinarily important that we draw attention to this, especially given the question marks about all these other things. And so I'm encouraging everybody to pay close attention and use your platforms, use your social media platforms. Everybody on this call has a bigger megaphone than anyone in an earlier generation to let the world know how important this is. I believe, Kitty, that you are with us and have some questions from the audience.
Yes, great. Thank you so much for that discussion. I mean, my head is spinning, but that's okay because there's a lot to process. I do want to pull back. There are some questions about the federal court system in general. So maybe we can take a look at sort of what's been going on around the federal judiciary, particularly some of the Trump-appointed federal judges, and also want to take a look at this struggle between Texas, a state, and SCOTUS, the federal government, at the border, and what you sort of see playing out. So, Judge, first of all, what has sort of disturbed you or made you feel, strengthened by what you're seeing some of these Trump-appointed judges decide? Some seem, in my opinion, very extreme, and some seem to uphold the Constitution. So what have you seen in these last few years?
Well, I've not seen that kind of dichotomy, Kitty, at
Okay.
all. First off, we all have to understand that there's three tiers within the federal judiciary: the district courts, the courts of appeals, and the Supreme Court of the United States. So before anyone can hastily claim that the federal courts are not enforcing the Constitution of the United States, at least you have to have the final decision on that matter from the Supreme Court of the United States. More specifically, I suspect that some of the decisions that you're referencing are decisions by the federal district courts.
Okay. Yes.
And in particular, a decision by a federal district court is temporary only, pending its appeal to the United States Court of Appeals, the relevant court of appeals. So I have said, with respect to some of those district court decisions that I suspect you're referencing, that the check and balance, if you will, within the federal judiciary is the appellate process, including specifically in this instance, the courts of appeals. So until or unless we have a decision on a fundamental matter from a court of appeals, from my perspective, it's premature. It's premature even to talk about a decision of the federal courts as a whole.
Okay, that's helpful. Michael, do you want to talk to us a little bit about this, sort of what we see as a struggle right now going on in Texas?
Well, what you're seeing, first of all, is a response to a real, genuine factual challenge at the border of so many migrants coming to the country, so much difficulty in keeping control of the border, challenges for cities and states all over the country in absorbing these migrants, and the need for a modernized and updated asylum law and immigration law, which, as we've seen even just in recent days, is stymied by the political paralysis and polarization in Washington. The last time the federal immigration laws were significantly updated, Ronald Reagan was, I believe, in his first term. And that is the underlying fundamental challenge. What you're seeing is increasing audacity on the part of states and governors, especially such as Texas, in challenging the primacy of the federal government in these matters. And there's a provision of the Constitution, the supremacy clause that makes it clear that on matters where the federal government has enacted laws like immigration, the federal government is dominant. What's happened is they put up their own fence, and it's a very open challenge both to the courts and to the executive branch. And 4 of the justices on the Supreme Court seemed in effect to side with what Texas was doing. I would say this is an interesting and unnerving moment in a broader way. I have a not surprisingly, perhaps a far more critical view of the federal courts right now than Judge Luttig does. I think on a number of different issues that the Supreme Court and lower court judges too, especially, have really veered in a direction that I think is a misreading of how the Constitution should be interpreted. The consequence of this is that you're seeing really in a lot of places almost 2 social systems rising up, and you're seeing states in effect challenging national norms in a way that we haven't seen in a long time. Before the Dobbs case, Texas in effect passed a law that banned abortion in Texas before the Dobbs ruling, which overturned Roe v. Wade and Casey about a year before. And it was a pretty unambiguous action by Texas. I think you're seeing this a lot, and I think that unfortunately you're going to see the connective tissue around the country fray in this way, because you're going to have the evolution of almost 2 different social systems and political systems depending on who has political power in a state. So I think that is one of the things to worry about. And while it's true that the Supreme Court has, for example, the Fifth Circuit is the appeals court in Texas and Louisiana, and actually has this Supreme Court has rejected the views of the Fifth Circuit repeatedly in the past year, when the Fifth Circuit has been more extreme. But the rulings by lower court judges can often have a significant and chilling effect in a lot of these cases in the meantime.
Kitty,
And the fifth, yeah, sorry, go ahead, Justin.
Michael is correct in his description and characterization of what's going on today in the federal courts. I would just make the point that Michael would of course agree with me on, that all constitutional history is made up of testing and challenges to government conduct, and of course some of the greatest constitutional decisions in our history arose from that kind of testiness, if you will, of government action. And foremost among those, of course, is the Brown versus the Board of Education. But that said, I would not want to be arguing on behalf of the states like Texas that are challenging the federal government's authority over the boundaries of the United States of America. That's an uphill battle. That's not to say that they will not win it. I don't know enough about the issues to say, But it's just to say nothing more than what I said. I would not want to be arguing the state of Texas's side of that case in the Supreme Court of the United States.
And interestingly, the Solicitor General during the Dobbs case and the Texas abortion case, rather, said, well, look, why won't more progressive states, blue states, issue gun laws that violate the Supreme Court's reading of the Second Amendment under the same principle and premise? So I think you may see more of that kind of thing happening all around the country.
Can you both, obviously we're focused like a laser beam on the immunity question on the Colorado case. Can you tell us what other cases at the Supreme Court they're going to decide on so many things that will affect all Americans? What should we be looking out for at the end of the term that maybe we're not focused on? Judge, do you want to start?
Yeah.
I think that probably the so-called blockbuster case of this coming term, other than the 14th Amendment case and possibly the immunity case, is the question whether the court should overrule the Chevron case. That's a very technical thing. I think that for your listeners, I would just say that Chevron for almost half a century has demanded that the federal courts defer to the interpretation of federal statutes by the agencies of the federal government. There's no question that some number of the Supreme Court today believe that Chevron has outlived its life, and thus the question is whether to overrule Chevron and replace it with a tighter standard under which the agencies would have far less latitude in the interpretation of federal statutes than they have today.
And this case is significant in its own terms. It's Chevron is the most cited case in the federal courts and by the Supreme Court over many years. It was actually a very favorite doctrine of Justice Scalia before he passed away. But it also comes as part of a broader set of challenges to the power of regulatory agencies, especially those agencies that protect the environment, worker safety, and things of that nature. There was a case from 2 years ago that I write about in my book, The Supermajority, West Virginia versus EPA. And that case was one of these very complicated cases tangled up about a regulation that had already never went into effect. But what was significant about that case, it was a climate change case. And in that case, the Supreme Court said basically that even if a statute properly can be read to give an agency the power to do the thing it wants to do, if it's too big a deal, it really has to be something that Congress, the elected branch of government, does. It's called the Major Questions Doctrine. It was the first time, as Elena Kagan pointed out in her dissent, that phrase, the Major Questions Doctrine, had ever been articulated by the Supreme Court. The combination of those two cases, assuming the judge is right about how the Chevron doctrine case, which is called Loper-Bright, will come out, is a significant curtailing, potentially, of the authority of federal agencies, regulatory agencies, to do what they do. And some of the power will be taken in effect by judges who will decide whether something is a major question or not. Putatively, the power is being given back to Congress, but since Congress has a hard time acting or has already passed the laws that authorize the agencies to do this stuff, it really ultimately winds up curbing, in realistic terms, the activism of the agencies. So it's going to be a big deal. And you're right, it's technical, and it's not as vivid as an abortion case or a gun case or a Donald Trump case.
Kitty, the Major Questions Doctrine was the Supreme Court just created that out of whole cloth. There's no argument that it did anything but that.
We will keep that at the top of the list. Quick question, gentlemen, and then I have a magic wand question for you. Did Clarence Thomas recuse himself from the Colorado case? Do we know?
Not to my knowledge.
Okay.
There's the only recent case that where the Supreme Court did anything was in their decision not to take an expedited appeal of the immunity case, and there was no reason to think from what we saw that Justice Thomas recused himself.
Okay. All right. There are a lot of questions about that, so I wanted to get to that. Okay. Lots of concern, obviously, about a Trump 2.0, about the plans that are very sophisticated, very detailed, about what would happen to the federal government. Checks and balances, will they hold? So I'm just going to ask you to wave your magic wand. You don't have to go through Congress or anything, but if you could change one thing about the Constitution to protect us from Trump 2.0, what would it be? This is a very unfair question. I didn't tell you I was going to ask you, but I'd be really interested to hear your response.
Well, Kitty, it has been famously said by former justices of the Supreme Court of the United States that the Constitution is not a suicide pact. And indeed, it's not. And it actually has within its four corners several provisions that were designed to protect America from an assault on her democracy. And all that needs to be done is for America, through the Supreme Court of the United States, to enforce those provisions of the existing Constitution.
I agree emphatically that the Constitution is fine and doesn't need to be changed. I think that there are steps Congress can and should take to live up to its role to defend checks and balances. It should have, in my view, convicted the former president in his impeachment on these matters. We now know that he wants to use the Insurrection Act, perhaps, to take military action against protesters. And when you look at it, it turns out the Insurrection Act has few limits on the president's ability to do that. That can be changed by Congress. There are steps Congress can take to protect the independence of the Justice Department, and other things like that, where the Constitution is just fine. Congress needs to act. And the Brennan Center, which I lead, is actually, even as we focus, as everybody does, on the extraordinary need to protect free and fair elections in 2024, we're also looking at 2025 and beyond to make sure that Donald Trump or any other president doesn't abuse their power and respects the checks and balances. And we've got a lot of work ongoing about that too.
Kitty, it is partisan politics and partisan politicians that are destroying America today.
So well said, Judge. And for the last few minutes of this call, I do want to say, Judge Luttig, that there's been so many comments in the chat thanking you for the stands that you have been taking, your courage, just really entering into the fray of what this time requires. And so few people are doing that. So I'd love to have you take us back, because it seems to have started in early January of 2021. Could you just tell us briefly the story of how you became a Twitter user and why you continue to be a Twitter user and such a force for democracy? And thank you so much for what you do. Well,
in brief, Kitty, first, it's I who thanks your listeners. Okay. I'm doing all of this for them and the many, many, many millions of Americans who are not in a position to speak out. But it all began on January 6, 2021, when the counsel to then Vice President Pence, a longtime friend of mine, Richard Cullen, asked me to get my voice out across the country as to the power of the vice president to overturn the election on that day, and that led to one of the first tweets that I had ever done, and I didn't even know how to do the tweet on that day, but I ended up tweeting with the help of my millennial son that the vice president had no power under the Constitution but to accept and count the electoral college votes from the states as they had been transmitted to the Congress of the United States for counting. And then I went on to say this is not a question of loyalty between the president and the then vice president, and it should never be characterized as such, as the president was characterizing it. That in fact, both men have no higher loyalty than to the Constitution of the United States. That day was the first of what has been the last 3+ years for me, in which I have felt that I had an obligation to explain to the country what had happened on January 6th, and then thereafter explain to the country the constitutional and legal consequences for what had happened on January 6th. And it's not something I would have wanted to do. That said, it's been a high honor for me, and in fact, the highest honor of my life, to have been privileged to discuss this entire matter with the people of America.
Judge, what will you do after this Colorado case is decided? What's next for you?
Well, I pledged to my wife that I would retire 4 years ago, and we've been married well over 40 years now, and she's beginning to be suspicious of my intentions. So I'm afraid I will not retire, but I would like to retire from this particular matter, and I feel like at that point I would owe that to my wife and to my family.
Well, I do hope that you'll come back to BigTent and that you will continue to be a voice for the United States Constitution and for American democracy, because I think you've made a huge impact on a lot of people, and you've crossed party lines, as it were, as you've said. You know, don't retire all the way. Please, Judge Luttig. I want to turn this call back over to Michael and say thank you so much to the Brennan Center and to Michael for moderating this call and helping us today. It was absolutely huge. We've put some links in the chat for you, so you can take a look at what the Brennan Center is all about and what they're doing. Michael, why don't you end the call for us?
Thank you so much, Kitty. Thank you, Judge Luttig, for all you do for our country. It's a privilege to be in this fight, the great fight for American democracy, alongside you and so many others. None of us necessarily thought we would have to fight for first principles the way we do, but with you in the fight, I think we have no choice but to prevail. And thank you, Kitty, to all of you and BigTent. We at the Brennan Center are very lucky. We get to work on these issues every day. As you know, so many of the folks on this call are supporters of ours. We are a nonpartisan law and policy institute. We work to strengthen and defend the systems of democracy and justice in this country so they work for all. I want to thank everybody who has supported us. I will note that we are surging in our work. putting everything on the table, and we hope that folks who support us could consider surging too. We are entirely funded by our 40,000 supporters, and I'll mention quite a few of you have been able to join us at the Brennan Legacy Award Dinner, which is a gathering this year in New York on May 1st, and we will be honoring Secretary Gina Raimondo, the Commerce Secretary, who is a leader on AI issues in the administration, and we'll be honoring retired Chief Justice Maureen O'Connor of Ohio and the Ohio Organizing Collaborative. She is the Republican Chief Justice, retired, of Ohio, who ruled against gerrymandering. Partisan gerrymandering is done by all parties, and the legislature ignored her, and so she decided that her next step would be to be a citizen. She's organized a ballot initiative for nonpartisan redistricting reform along with this grassroots group. We're honoring them too. We hope any of you who can join us can join us. It's actually a great, fun event. And thank you to everybody who's part of this movement. We all know there's an election denier movement. It's pretty scary sometimes, but there's a democracy movement. It's big, it's strong, it's growing. And I hope and think it will be the story of the coming years.
Well said, Michael. Thank you so much, Judge Luttig. A real privilege and an honor to meet you. Michael, thank you so much. Everyone, hope to see you under the tent